Good afternoon, everyone. Just going to wait just a moment here to see if we'll have some more people that'll come on board. I didn't really give everybody a ton of notice, so we have some people coming over from Facebook and Twitter, as well as some other places, so I'm just going to give a few moments just for that. I do want to let everyone know that if you are, oh shoot, that's what I forgot to do. I will grab a link here. I'm not sure if it's going to, Rachel, since you are on, is it possible for you to go to our website under the document section, the very first one listed under government documents? Can you copy and paste that link from that right into our comments here? Quite frankly, any of you, if any of you could do that, that would be great. I did have our tech team upload the most recent Michigan Court of Appeals decision from Friday in the lawsuit against the Secretary of State. And the legislature intervened in that lawsuit. I'm glad they did, because the Secretary of State chose, well, basically, I'm not even going to go through all those boring details, but at any rate, looks like we're having some more people. As soon as I see the link posted in the comments from someone, I'll go ahead and officially get started. You can't do that. You're shaking the table, baby. You guys are very welcome. So I'm just looking here. Oh, and she's got it. So, all right. So looks like Lori was able to post the link there. If you see Lori DeVries, look at her comment. She has the link to restorefreedomkh.com, where it is the Court of Appeals decision from Friday. It is dated the 16th of October at 9 a.m. Wasn't sent out to those of us who were not participating in the case until Saturday morning. Baby girl, you cannot keep bumping the table. Sit down in the chair correctly, please. Thank you. Okay, so what I wanted to do is just give you guys a little bit of an update about that. So this was a 3-0 decision. There was a concurring opinion filed in this case, but that I did not post to the website, but it was concurring. So it agreed with the conclusion, but as with any concurrence, the judge who wrote that just felt there was something additional that needed to be added to the opinion that had been provided. So the court explains here that the legislature, who again wasn't an initial defendant in the case, but they were an intervening defendant in the case, and my understanding is they tried to intervene and become part of the case initially, and the Court of Claims judge originally ruled against that motion, but subsequently they were able to intervene in the case and become a party to the case. So on September 30th, there was the order from the Court of Claims that granted declaratory and injunctive relief in favor of the plaintiffs, who officially are titled as Michigan Alliance for Retired Americans, the Detroit Downriver chapter of the A. Philip Randolph Institute, Charles Robinson, Gerald McMurran, and Jim Peterson. So essentially, there is a group of individuals that were challenging laws related to absentee voting. And most of you who are tuning in right now already know of that. You know of the concerns. We've been very frustrated with what happened there. And I had briefly explained some of the reasons why in some prior videos that the judge would have done something like that. Not that I agreed, but I understand, I at least understand some of the concerns, more so than some of the other things that have been happening in the Court of Claims in Michigan this year. And so anyway, on September 30th, the Court of Claims judge ruled in favor of the plaintiffs with respect to the receipt deadline for absentee ballots, basically saying that as long as the at the ballot was postmarked by the day before the election, so November 2nd. Emma, you cannot be leaning on the table. Sit down appropriately, please. Thank you. As long as the absentee ballots are, in fact, postmarked by the date before the election, then they can be received afterwards, up to 14 days afterwards, and still be counted, which would, of course, make our election take, well, 2 weeks longer than it's supposed to take here in the state of Michigan. And also had ballot handling restrictions that limit those who may lawfully possess another voter's ballot. So essentially, they were challenging the ability, they wanted to make sure that anybody could go and deliver somebody else's absentee ballot for them. A lot of get out the vote organizations were really pushing on this. Of course, those that really are worried about voter integrity and election integrity were not so happy with that. So you'd be pleased to find out that the Court of Appeals, in this unanimous decision, for the reasons stated later on, they reversed. So this is, and again, this is something where the original named defendants, the Secretary of State, did not choose to appeal the decision from the Court of Appeals. Surprise, surprise. The legislature, which had appeared as amicus in the Court of Claims proceedings, they successfully intervened and filed the appeal on behalf, essentially, of the state. And I'm glad that they did do that. The Republican National Committee and the Michigan Republican Party they appeared in the appeal as amicus parties. So that is, for what it's worth, that's who was participating in this particular lawsuit. And so what I did, I'm not going to go through all the reasons why. I just wanted this to be a very quick update for you as far as the outcome of this case. This 3-judge panel on the Court of Appeals, they reversed the lower court, the Court of Claims. They reversed the Court of Claims decision and remanded for the immediate entry of summary disposition in favor of the defendants. So in favor of the legislature, essentially, and the Secretary of State, who doesn't want to win this case because our current Secretary of State wants the plaintiffs to actually win this case. But anyway, what's important to note, especially with how the governor in the case that the Michigan Supreme Court heard on September 9th, when the Michigan Supreme Court came out with its decision on October 2nd, of course, the governor came out and said, oh, my orders have another 21 days, which is a total load of garbage. And I explained that. And although she realized that, I think at some point during the weekend, because by Monday, she had quietly filed a request with the Michigan Supreme Court to have some additional 28 days for her orders to take effect or to be in effect. Sorry, I lost my train of thought when my computer made random sounds there. She made this big deal about how she has this extra time, right? And so one of the things that became at issue in that, and in fact, in this very quiet appeal or request, I should say, from her attorney to the Michigan Supreme Court was Michigan Court Rule 7.315. 7.315 has an analogous part at the Court of Appeals level, because that's the Michigan Supreme Court rules. 7.215 is the court rule as it relates to the same thing, but in the Court of Appeals. And so in that court rule, there's essentially this discussion of when certain court orders take effect and when opinions of the court take effect. And in many instances, such as in this case, the opinion would have waited a period of at least 3 weeks to take effect unless the court had said that the opinion takes immediate effect. Now, the good news is, not only did the Court of Appeals in this case on Friday morning come out and say, listen, Court of Claims, you got this all wrong. We're going to stick with the way the law is written, and the ballots have to be in when they're supposed to be in. But this court also said that this opinion has immediate effect. So as of, what the court rule says then is that as of 9 a.m. on October 16th, this opinion goes into effect. There's no more delaying it. There's no more arguing that there's an additional time for the Secretary of State to do something or drag their feet, or for the plaintiffs to do something in this case. And so that closes out the file at the Court of Appeals level. I have no idea if the plaintiffs plan on filing an appeal, but at any rate, that's where it stands. I was just trying to find if there was one last piece I wanted to read to you out of here. At any rate, it's good. It's definitely a good thing. So what the court said here is that the question before this court, the Court of Appeals, is whether the requirement that clerks provide voter assistance only until 5 p.m. on the Friday before an election, in addition to the COVID-19 pandemic and the asserted delivery slowdown at the USPS, imposes an unconstitutional burden on the right to vote absentee. And we conclude that it does not. So first of all, they say, even with the 5 p.m. limit, voters are not deprived of the choice to vote absentee. They retain all the options of delivering their ballot in person to the clerk, using one of over 1,000 drop boxes in the state, using community satellite voter centers, if available, or relying on any family member or household resident to do so. And then they talk about how that part of the law allows for certain people to drop off ballots and things like that. So at any rate, they go over some more provisions involved there, but that's something I just wanted to bring to your attention, that we do have a win where we seem to not have very many wins when it comes to expecting our government to follow the law when it's constitutional and follow the Constitution always. Today, we can actually celebrate in a victory with the Michigan Court of Appeals that first of all, let's applaud the legislature, because quite frankly, they've not been doing very many good things for us with this whole COVID-19 pandemic. They've let us down in a lot of ways, tried to slip by all these bills that they're claiming are helping us when they're not, but definitely let us down when they voted for the extension for our governor to have the additional days through the end of April with the state of emergency. But what we can focus on is that the legislature did in fact choose to intervene in this case, that they pursued it even when the Secretary of State would not. And by filing this appeal, it allowed the Court of Appeals to have this opportunity to do the right thing, which they not only did, but they did so. Again, it was a totally different panel than the judges that ruled against the legislature in the other lawsuit back in August. But this panel ruled unanimously in favor of following the law as it is written and getting judicial activism out of government there. And so this was a win for us. And the fact that it goes into effect immediately was also a win. Couple other updates real quick. The Secretary of State is also, sounds like, going to be facing a lawsuit by at least one Second Amendment's group in Michigan. I did get confirmation today that they are working on it right now. And that is, of course, in response to the, let's see, I think that might have also been on Friday when the Secretary of State came out and said, oh, by the way, I'm now going to also unilaterally decide to make laws for Michiganders, even though I'm in the executive branch, and I'm going to make it a law that you can't bring an open carried weapon into a polling precinct. She can't do that. She can't make laws, and she certainly can't try to get law enforcement to enforce her unilateral edicts. apparently they don't learn very well over there in the executive branch these days, because that whole concept of trying to create laws and have law enforcement enforce them was just struck down in the Michigan Supreme Court. So that's very interesting that they're trying to play these games. But at any rate, I did hear that there is a good, reputable group who is going to be fighting this very issue in court very soon, and is working on that right now. So I just wanted to give you the news in that regard, give you the great news that the battle was already won with regard to absentee voting, and it's all a anyway. Those are all good updates. So the last main update, I guess, that I have for you is that I officially have now heard that the Recall Whitmer group is in fact going live, I guess, with the petitions October 23rd, and that they are going to be doing the same thing that we are as Restore Freedom Initiative with our petition. And we are, both groups are going to be working at polls all across the state, needing volunteers to sign up to work the polls, to be able to circulate the petitions. And if you're circulating one, you might as well circulate both. And so, interestingly enough, we have a volunteer with our organization who is also a volunteer with the Recall Whitmer organization. And his name is David. And he is going to be able to answer any questions that you might have about the election day setup. But if you are interested in helping us fight this fight, both petitions, like I said, are going to end up being circulated on that day. And he's kind of the one-stop shop. That guy is wanting to really help circulate petitions for both organizations on that day. And on our side, we have a set up a link on our website, restorefreedomkh.com/election day. And I believe that Recall has a similar thing set up. I want to say it's recallwhitmer.com/election day. Hopefully, if David or one of the others is on, they will be able to clarify that. But please make sure to sign up. Even if you're only able to help, we're doing 4-hour chunks of time. So if you are able to help, say, in the morning, or actually, they're not all 4-hour chunks. It is the 13 hours of voting divided into 4. So if you're able to help for just a little bit, or if you're able to help for the whole day, that's great. We'd love to have you on board. We have a training video we'll be rolling out to you shortly, and a little election day success kit to make sure that you know your rights. Because clearly the Secretary of State wants to keep all kinds of legal things out of the area. And this certainly is one that we have a First Amendment right, and certainly a right under our state constitution to petition our government for a redress of grievances. These two very petitions are essentially what is covered by those very provisions of our state and federal constitutions. So we're putting together some explanatory information so you know what your rights are in that regard, and we can get you plugged into certain counties. If you are able to help with that, but you can't go to one of the 21 counties that we're going to be spreading out throughout, we'd still love to have you help on election day. You can go to your own polling precinct. We just wouldn't be coordinating that to make sure that we have coverage for the entire day. But we'd still love for you to take the training, watch the short training video that we'll have, and utilize yourself of the resources that we have available to you through our website. And like I said, I believe the Recall Whitmer group has some similar stuff going on. But if you want the one-stop shop guide to be able to answer all those questions, you can sign up through us. And David will be the main volunteer who's wanting to coordinate the efforts on both sides. So it works out great. So again, for us, that's restorefreedomkh.com and kh.com/election day. So let me look here to see if we have any questions real quick. And you're bumping the table. Thank you. So I did have a question. What do I say to David Coleman saying that private businesses do have the right to refuse you service without a mask? Let me put it this way. I didn't watch his video. I don't know why Stand Up Michigan would be peddling stuff saying that businesses can exclude you from being a customer simply because you're not wearing a mask. That seems really ridiculous to me. So we have, let's just look at one piece of the argument, right? This isn't the whole big picture because I didn't know that was going to be a question today. I'm doing this off the top of my head. So let's just look at the, one piece of the argument. Let's look at Article 1, Section 23 of our state constitution, and also the 9th Amendment to our U.S. Constitution. It says that just because we have rights that are listed and enumerated in other parts of the Constitution does not mean that everything else is gone. We have unenumerated rights. And in fact, let me just pull the actual language so you guys can follow along with me. It is the 9th Amendment I'm talking about. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So we have rights that are not listed in there. They don't need to be listed by a government agency. They don't need to be listed through a series of court cases that total up what all these unenumerated rights are. That's just ridiculousness. If we needed the court to spell out all these unenumerated rights, then we would have just spelled them out ourselves. We chose not to do that. The founders chose not to do that. And in our state constitution, for those people who want to argue and say, well, this government document's so old. Well, it's still just as valid. But for those of you who want to go with something a little bit more recent, how about the state constitution of 1963? That's not that long ago. And in there, we reiterated that same concept as it's been in our state constitution all along. That is Article 1, Section 23 of the Michigan Constitution, which almost word for word copies the 9th Amendment to the U.S. Constitution, which says, again, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So we have a right to breathe fresh air. So what's important about this? Well, the whole point of government, and just to stick with state government, let's just go with that for a minute. Here in the state of Michigan, we, the people of the state of Michigan, grateful to Almighty God for the blessings of freedom and earnestly desiring to secure these blessings undiminished to ourselves and our posterity, do ordain and establish this Constitution. Stop, child. Okay, homeschooling is so much fun. So our whole point of government. See, I guess I should have realized this question was coming, but give me a second here, because I will answer this. It brings it back to what the whole point of government is, okay? And so a bunch of court cases here. Okay, so one part, and this I am getting from the case of Twitchell v. Blodgett, a Michigan Supreme Court case from 1865, that a state constitution proceeds from the people in their original capacity as the source of all power in government. Our Supreme Court has clarified and reiterated and stated again for us that the state constitution comes from the people, and it is the people who are the source of all power in government. Their will, the people's will, being the supreme law and only to be found in the Constitution which they ordain, must be fairly and cheerfully enforced according to its terms, and no attempt should be made to evade or defeat it. And the language must receive such a construction as is most consistent with plain common sense, unaffected by any passing excitement or prejudice. So regardless of if it's a COVID-19 pandemic situation or the bubonic plague or anything else, We, the people, retain ultimate authority and power in our government, and we give certain amounts of authority to government officials through the Constitution. That's what this is explaining in different words than what we've already talked about before. And so the terms of that Constitution have to be applied to effectuate the most common sense, logical terminology when it was put into place in the first place. And it continues by saying, as the Constitution derives its force from its adoption by the people, we should, in its construction, seek only for the sense in which it was understood by them. So again, the whole point of government is to, it's not exactly the point I was going to try to bring forth here, but I'm trying to find this off the top of my head here. So if you bear with me. The whole point of government is to secure our blessings of liberty. Okay, so this is a bunch of court case language. Normally, if I would have seen this question coming before the video started, I would have pared it down to, you know, definitely the most succinct, but just bear with me. I'm doing this on the fly. So a constitution, and this I'm getting from the Citizens Protecting Michigan's Constitution versus the Secretary of State case, a Michigan Supreme Court case from 2018. And I'm also, I'll also after that be quoting part of the case of the New York versus the United States, a United States Supreme Court case from 1992. So a constitution is made for the people and by the people. For as the Constitution does not derive its force from the convention which framed, but from the people who ratified it, the intent must be arrived at is that of the people. Okay, so we're having to look at the intent of the people of the state of Michigan when interpreting the Constitution, including Article 1, Section 23. What does it mean to have unenumerated rights? Not only is the Constitution the bulwark and foundation of our laws, but that very foundation does not protect the sovereignty of the states for the benefit of the states or state governments as abstract political entities, or even for the benefit of the public officials governing the states. No, the whole point of having a constitution is there so that we are protecting individual liberties, not a collective liberty. And so our state constitution, indeed our state constitution proceeds from the people in their original capacity as the source of power in all government. We already went over that. So basically, he's wrong. I'll say that. But we need to, and I'm not finding for you exactly what I wanted to highlight for you here today. It's here somewhere. Yeah, I'm not finding exactly what I wanted to share with you here, but I will go over it again in future videos for sure. My point is, the whole point of government is to secure our blessings of freedom. Secure our blessings of freedom against whom? So if you look at the Ninth Amendment to the U.S. Constitution, or Article 1, Section 23 of our state constitution, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So when we're talking about what the purpose of government is, the whole purpose is to secure our blessings of liberty. Well, secure them against whom? Well, when you come together as collectively as a society, we're trying to secure our individual blessings of liberty that we have. And so to the extent that any kind of entity or individual is trying to squash the individual liberties of another individual, then that's where government steps in. And if it's doing its job, that's the only time government steps in and tries to break it up, so to speak, so that each individual is allowed to exercise their own individual liberty given to them by God, because the government didn't give us our rights. So when you have an individual who simply wants to breathe fresh air, and then you have another, a company policy of a private organization that says, no, we're not going to be able, we're not going to let you in. We're going to discriminate against you. But no, it's not discrimination. Let's put it this way. There's no absolute right in that regard. So, for example, would it be lawful? Would it be constitutional for me to walk in to, let's just say Menards, for me to walk into Menards and have them stop me simply because I'm white? I would think not. I would think they would not be able to discriminate against me on the basis of my race. Now, the Supreme Court has already declared that's a hugely protected class, and we do have, in fact, other. I want to say we have criminal statutes on the point. I want to say 18 USC section 242. Is on point and says that if you're discriminating against someone, if you're denying somebody the ability to exercise their the rights that are protected either by law or by the Constitution, and that discrimination is on the basis of their skin color and a few other particular classes, that it's a crime, it's a felony. So we also have some other state and federal statutes that prohibit that as well. But even if we so I'm not talking about all those. I'm talking about the very language and essence of the Constitution. The Constitution is there to secure us the opportunity to enjoy our liberty, our individual liberty, and to make sure that we're not inhibiting the individual liberty of others. So would Menards be able to deny me service if I came up to the front door and expected to be served, but I was in a wheelchair and they wanted to discriminate against me on the basis that I was in a wheelchair? Same thing. No. Again, we have a bunch of statutes that have been put out there on the same point, that kind of thing. So I'm not talking about those. Let's use common sense and the Constitution, because the Constitution is at the basis of it all, right? State or federal. And so, no, our Constitution would not allow that. That is one of those very concepts that simply because of an individual's disability, a private organization that is generally open to the public cannot discriminate based on that. So let's say, though, for example, I work out of my own home. My home is not generally available to the public. And so if somebody came to my house and they wanted to, try to hire me for my legal services, my house is not handicap accessible. The ADA would not apply here. This is not a building that's generally available to the public. It's not how it's set up. It's in my home. So let's just apply the Constitution and some basic common sense. We all have the right to breathe fresh air. We also can't do anything about the color of our skin or whether we are in a wheelchair or have some other sort of physical disability. So to the extent that an individual wants to discriminate against us for any of those things, that makes no sense. As far as if it's wearing a mask, not wearing a mask is not akin to breathing a deadly contagion, right? The science is so far from settled on this. In fact, I would truly love to see what science and data these so-called experts are that are trying to mandate the masks in the first place. Because the only science and data that I've actually seen out of anything, whether it's what CDC has put out there, what the World Health Organization has put out there, or any of these private universities and medical centers have put out there, across the entire world, is that by wearing masks, you're actually increasing your risk of respiratory illness. You are increasing your risk of bacterial infections in your mouth and in your gums. You are increasing your risk of facial, issues or conditions on your face because of the bacteria building up from wearing the masks. You're increasing your risk of headache and for some people, stroke and other symptoms because you're reducing the amount of oxygen that you're breathing in all day long. Not to mention that the CDC alone has pointed out that those who are seeing in areas where we're seeing these bigger upticks in COVID-19, it's mostly, vast majority of these cases are being seen in populations where the individuals are always or almost always wearing a mask when they're in public. Whereas if you look at the individuals who are never wearing a mask when they are in public, that percentage of people who are getting COVID-19 now is this big, because that is not how our bodies are designed to function. That's not even considering any of the religious freedom arguments or anything of that nature. So there's, and it is a discrimination thing. So let's think about it this way. So people who are callous, like attorneys or grassroots organizations that are out there claiming that it's totally legal for people to discriminate against individuals for not having a mask. What about someone in my condition who I not only have a medical reason for not wearing a mask, but I have a hearing condition? And not only can I not wear a mask, but those around me, because of my hearing condition, I read lips. So for me to be in a restaurant or in a any other place of public accommodation, a Menard store or something like that, when I go in, I'm asking them very kindly if they could remove their mask so I can read their lips, so I can communicate with them. Because simply screaming at me often does not help, especially if it's a loud environment. So, and some men's voices I'm able to hear a little easier than others, but most women's voices, quite frankly, all women's voices and most men's voices, and certainly children's voices, I typically cannot hear out of my deaf ear at all without lip reading. So individuals like me, I'm not unique in that regard. I'm just representative of a whole population of people that are out there that are hard of hearing. And for us to be totally cut off from participating in sales or services because of this disability, that's totally unacceptable. So to be able to say, well, sure, any business can totally discriminate. It's okay. It's their private property. That is not how we have envisioned living together in a society where we have come together to not have collective rights. We have individual liberties, but we want to ensure that our individual liberties are not trampled upon by others by merely coming together in society. So you need to take that off the table. You keep shaking it this whole time, and you're reading out loud, which is beautiful, but not during a video that I'm trying to explain people the Constitution. Funny thing is, she's reading about freedom in her homeschool book right now. So anyway, hopefully that answers the question for you. And hopefully that explains, who knows if that person's even watching the video anymore. It was Elizabeth. So hopefully that explains that question for you. I will continue to put information together. In fact, I have 1 hour left before I have to leave my house, and I have to put together some information for a team member of mine who's going to a school board meeting tonight. And in fact, I believe that we are going to have a live video feed from our Facebook page to broadcast for people how a parent, a typical non-attorney parent, the parent of a special needs student, is going to stand up and speak as a parent to a school board, duly elected individuals who took an oath of office, and how to hold them accountable and how to educate them on what the law and the Constitution actually says. So I hope you tune into that in just a little bit here, but hopefully that also gave you let's see. Same, Elizabeth, you are stumping me today, but I see that you have a question here about making a short shareable video about MDHHS and what they can and cannot do. I don't mean this to be rude, but there is no short shareable thing. The shortest video I could do was the hour-long video I did last Thursday, right before I went to pick up my son from the airport, when I had written out all the provisions of the Constitution and state law that MDHHS is using and explaining the different roles. I had the whiteboard behind me. I subsequently posted a picture of that very beautiful handwriting that I had on that whiteboard so that you guys could have essentially that as the summary version of it. But if you want to understand how all these pieces play together, I still have the board up in my office. These are just the parts that were involved with that question alone. Article 1 of our U.S. Constitution, Article 2, Article 3 of our state constitution. It was Article 4, Section 1, Article 5, Section 1, Article 6, Section 1, Article 3, Section 2, Article 5, Section 2. Several state statutes, MCL 8.8 and 333.2253, 333.2453, Article 1, Section 23, and the 9th Amendment to our U.S. Constitution, and Article 6 of our U.S. Constitution, Article 11, Section 1 of our state constitution, and MCL 15.151. Those were all the specific provisions that I had on the board. And then I mentioned things about health, safety, and welfare to give people that additional information where those terms are mentioned and are not mentioned in our U.S. and Michigan Constitution. So if you're looking for something more simplistic than that, basically the three things that I itemized in the middle of that board that I talked about on Thursday, they can prohibit a gathering for any reason. They can't under the Constitution, but that's what that particular law says. They can ensure continuation of essential public health services. They can continue to offer services. They can't require masks to be worn. They can't require anything to be done. They can offer services. So they could offer education. I could argue that they could even offer supplies like face masks or face shields or hand sanitizer, those kinds of things. But they can't require people to do anything. And the third part of that is they can enforce health laws that are already on the books. There's no other health laws that they're trying to utilize. That is what they're saying allows them to require masks, which it doesn't. So at any rate, that is unfortunately the shortest that I can provide for that. I understand that people don't want to take the time to watch the whole thing. The unfortunate part of it is, again, I didn't write all the complicated laws. If it were up to me, in fact, if you guys, well, I don't have my petition here right in front of me, but if you help us to sign and circulate the Restore Freedom Initiative petition, then when it gets on the ballot in November 2022, all of this is going to be irrelevant. All of this complication and garbage is going to go away because government's not going to be able to do that. There's so many provisions in this constitutional amendment that require the laws basically to follow notions of common sense and have to be understandable by the average reasonable Michigan resident U.S. citizen, right? That they have to be, we can't overregulate the people. That's all that government does. They go in there every single session, whether it's a member of the legislature we're talking about at a statewide level or a local level, and they're constantly making new laws and new regulations. They're just trying to create more and more at every session. Really what they need to be doing is repealing those. Okay, I'm just looking to see what other questions. Oh, and Rachel, I guess, is going to be attempting to make a shorter version. Rachel's on my team, so let's see. Just trying to scroll through very quickly to see if there's any additional questions that I could answer for you. Is there anything else that could be done about the Secretary of State charging late fees when you cannot get an appointment? Oh. Interesting. I did not realize that they were actually imposing late fees for not being able to get an appointment. Definitely, I would not pay a late fee. Unfortunately, the way that this works, in order to get, say, for example, your license, you're going to have to pay the late fee for now and probably take them to court to get your money back. But I would definitely do that. It would definitely be worthwhile because you'd have the law on your side. Absolutely. Yeah, I don't know what they're saying, that it'd be a federal rule that you have to wear a mask. That, again, federal government can't mandate it because the US Constitution doesn't allow for that kind of thing. Ninth Amendment to the US Constitution is just as important as all the other amendments and provisions of our Constitution. Okay, so I don't know. It looks like I'm trying to scroll very quickly and see. Interesting. I don't know anything about it. Doesn't look like you're asking me a question, but it looks like someone is sharing that Stand Up Michigan is suing the Secretary of State for not verifying all the signatures that were turned in. Apparently, she's saying it could be 2022 before she needs to let this go through. I'm not sure what to say about that other than if the legislature chose to not act, the law says that assuming that Stand Up Michigan turned in all the right amount of signatures, and if the legislature chose not to do anything about it, or they, for whatever reason, didn't have the votes that they needed to get it through, then that petition would also go on the November 2022 ballot, the same as the Restore Freedom Initiative petition will. So, okay. So someone is asking about the decision that I was just talking to you guys about from the Court of Appeals, the original reason why we did this video today. If the Secretary of State can appeal this decision. Now, quite frankly, the Secretary of State, I don't think actually can, because they technically won. They were being sued, and although they didn't file the appeal, the legislature stepped in and intervened and filed the appeal. Their position or their office won. And so it's the plaintiff in the case right here who, in theory, could file an appeal. They might very well do that. I don't know. And that would be brought to the Michigan Supreme Court. So somebody mentioned the Nestle petitions, and then my whole thing just skipped here. So I don't know where I was. That is very frustrating. So I did hear that MIOSHA is trying to put some new rules into place that essentially cement some of the same provisions that the governor had in her executive orders. I have not had a chance to review those, but MIOSHA is also not the legislature. And the analysis would look a little bit different if MIOSHA is putting into place rules that try to do the same thing that the governor could not do. Again, the way the court resolved it, it would be a little bit different analysis versus how MIOSHA is handling things. But as far as what I've been explaining to people about how we have rights and how the government cannot trample upon those rights, even in times of emergency, we don't have just less rights just because times are scary. All of those things that I've been explaining to people and that I put in the briefs and things that are available to you on the website, all of those things would be in place. So MIOSHA doesn't have any more right to trample over our constitutionally protected God-given freedoms than the governor does. But the way to stop that or to fight against that is just a different mechanism. So, okay. So 120 days to verify. Okay, so I'll see if I can very quickly find that. Somebody is talking about in the event that so when the signatures have been turned in by Stand Up Michigan, the Secretary of State has a certain number of days to go through those signatures and move it on to the next stage of things. So I'm just going to see really quick if I can find that in here. And I don't see that in here in this section. So I don't believe it's in the Constitution. It must be in the law. And I am not sure about whether she has 60 days or 120 days off the top of my head. I used to have that stuff in there, but now I've had a few more things that we've been working on. So, okay. And it looks like, okay. Yeah, Shelley, if you wanted to send that letter our way, I'm not sure possibly if you can even post it here. Then somebody from my team could see it. I will definitely look into what statute she's claiming she's resting upon, and I can do something to explain that. Surely I can do that. Yes. And I guess I haven't seen Senate Bill 857. That must be the one that is trying to repeal the 1945 law. So, which quite frankly, what grounds would the governor have to veto that? They wouldn't even need a supermajority to get it through at this point, because the governor literally has no grounds. It says that it's the Supreme Court has declared and explained that it is unconstitutional. So, someone is asking if stores can force you to have your temperature taken. No, that's an invasion of privacy beyond all common sense. Temperature doesn't mean anything. It's certainly not the end all signal to a store owner that you have COVID-19 and that you must be excluded from all service. That doesn't even make any sense. You could have a wide variety of other things going on. You could have just come from the gym. You could generally run a higher temperature than others. We're not all exactly the same, but at any rate, they don't, no matter what, they don't have a right to be able to get any of that information from you. That's definitely an invasion of your constitutionally protected freedoms. So with that being said, this ended up being a much longer video than I intended. And I answered the basic questions that we had about what was happening with the Secretary of State and the lawsuit that was resolved on Friday by the Court of Appeals unanimously, as well as letting you guys know that there is in fact a lawsuit on its way against the Secretary of State for their newfound hatred of open carry. And despite that being a constitutionally protected freedom that we have. So just wanted to give you guys all the updates on that. And again, just keep checking our website as well for additional information. For those of you who tuned in a little bit late, please do check our website, restorefreedomkh.com. Go to the resources tab, and there's government documents. And if you look there, the very first government document that is listed, it has the whole majority opinion for the Michigan Court of Appeals decision that came out October 16th at 9 a.m. So you'll be able to read that. And that's the decision we are going over today. So with that being said, I want to wish all of you a wonderful evening, and I will look forward to touching base with you all soon. Thank you. Have a great day.